Your indulgence, I'm going to start the public hearing. We don't have a quorum yet, and let people speak on the public hearing, and then come back to you if that's okay with you, sir. Thank you very much. We have a public hearing called. We have 1, 2, 3 people for, and 3 people against. So I would like you to limit your comments to about a minute, and we'll start first with Carol Mosley for. Carol, come on up and tell us where you're from and let us know what you have to say.
Good morning. I'm here on behalf of the League of Women Voters of Alabama. Thank you for having me here today. The League has been working for more than a century to help all citizens be informed and engaged voters. I'm here today because the League of Women Voters of Alabama believes that democratic government depends upon the informed and active participation of its citizens, and that an informed and active citizenry requires an open and accessible government. Unfortunately, that is not the case in Alabama currently. At present, state agencies and local governments can choose to ignore, deny, or charge exorbitant fees for citizens to access records. While current Alabama law establishes that every citizen has a right to inspect and take a copy of any public writing of the state, governments in Alabama can make it difficult, if not impossible, to exercise this right. A right which you can't exercise isn't really a right at all. These records, which are created by public employees using public money to document the work of public agencies, belong to the public and should be open, accessible, and affordable. In order for our governments to be transparent and accountable, public records must be open to people and the press. I know there is concern from state agencies and local governments about the capacity to handle records requests from the public. However, these concerns should not be used to circumvent the rights of its citizens to access public records. And unfortunately, we see case after case of financial or ethical violations from public officials who think no one is watching. Open records help keep public officials accountable, and other states have disproven the hypothetical concern about overburdened governments. Not a single small town or county has been forced into bankruptcy due to someone asking for excessive copies, meeting minutes, or lists of permit applications. Senate Bill 165 would ensure that government records are accessible to citizens, the press, and watchdog organizations. The bill creates reasonable timelines for governments to respond to records requests, implements affordable costs for acquiring records, establishes which records should be confidential to protect privacy and security, and creates the position of public access counselor who will decide if a records request denial was warranted or unjustified. Also, state agencies and local governments can be fined for failing to comply with this law. In conclusion, the League of Women Voters of Alabama, on behalf of all of our members who are following this bill attentively, urges you to support the Public Records Act so that our citizenry can exercise our right to access public records and to keep our governments transparent and accountable.
Thank you very much. Mr. Kinney, and I will run. Please keep your comments to about 1 minute.
Mr. Chairman, members of the committee, I'm Philip Kinney with the lobbying firm of Barton & Kinney. We represent the Alabama Probate Judges Association. Mr. Chairman, I'm going to make it even briefer than 1 minute. With the help of the sponsor and the proponents of this legislation, I believe we have worked out all, if not most, if not all of our concerns that we had with the legislation, and we look forward to continuing to work with the sponsor and the committee as we move through the process.
Thank you very much. Senator Smith.
What were those concerns, and what is it that you worked out?
So there were a couple of things, and I don't have the language, Senator, in front of me right now. There were a couple of things. One, dealing with requesting documents and formats that aren't available to that particular probate judge, or it applies to everybody, but this was our concern. So, for instance, not every probate judge has the ability to create PDFs to send things off and those types of things. So we worked out some language on that, and then I believe we worked out some language on because it took the cost down pretty low, and it would have been a significant hit to budgets for the probate judge and my client, but and others as well. So I think those are the two major things.
I just want to say that probate judges do have a unique problem, not necessarily only in this bill, but they do, because out of all our unified judicial system, they don't have a consistent means to electronically file. That's right. And that's what most people don't understand. That it's not like in a civil case or a criminal case where you can go and file electronic and pull everything. Probate is still kind of antiquated. Yeah. And I mean, even in the largest county in the state, sure, it's antiquated. Yes. You know, so I can understand that you would be trying to address some unique situations that yes, may be unique to probate.
I think, and correct me if I'm wrong, that in civil cases and criminal cases now, you're required to file electronically. The lawyers are, so that's certainly a difference.
Thank you, Mr. Kinney.
Thank you, Mr. Chairman. Thank you, committee.
Mr. Scott Duff.
Good morning. My name is Scott Duff. I'm the news director at WSFA 12 News in Montgomery. I've worked in television news for almost 33 years plus, and 15 years as a news director here in Montgomery. Senate Bill 165 is a great first step of improving Alabama's open records law. Special thanks to Senator Arthur Orr for introducing this bill and the League of Women Voters who pushed to have this public hearing. This new bill would add structure, accountability that is sorely lacking in one of the weakest open records laws in the country. Alabama's current law is subject to interpretation of the agency when you try to obtain public records. If the agency does not want to respond, you must take legal action in many cases. Under the current law, there is no consistency. Some agencies are responsive, there are costs, there are agencies that do it right, however, there is no clear process. Short of filing suit, there is no accountability. There is a cost for citizens, cost for taxpayers when a suit is filed against a government agency. This does not have to happen. In many cases, this doesn't have to happen. In many cases, the media does win. And this court cost is then passed on to the state and city for the citizens to pay. And that's a situation where access should have been given from the start. We are not trying to obtain documents that we are not allowed to get. These are public records. Open public records are just that. There was a time when Alabama was way ahead of the rest of the country in recognizing the important role in the media in keeping citizens of this state informed on the issues that affect all of us. As the Alabama Supreme Court said so eloquently back in 1941, the function of the press in gathering information for this public to enable public affairs to be intelligently discussed is of great importance. That was Holcomb versus the state in 1941. The state.
Can you wrap it up, Mr. Duff? I mean, we got a lot of people to get through.
I understand. The state also said that this is a sensible, strong, enforceable public records law that is essential to enable the citizens of this great state to engage in intelligent and informed discussion of the public affairs. Open records laws are the lifeblood of our democracy. This is about accountability. This bill would make Alabama better for all Alabamians. Lawmakers, law enforcement, and state and local governments.
Mr. Duff, I've heard some committee members say we think you made your point.
Well,
if you get some comments, you can
well,
certainly
let me
give
finish
them.
by saying this.
Okay, hurry up.
This bill is about government transparency. I am certain you value accountability, the truth, and knowing how tax dollars of hardworking Alabamians are being spent. You can show citizens today you care about these values by supporting and voting for this bill.
Thank you very much. And Mr. Sonny Brasfield, do you want to speak? Keep them short, please.
Yes, sir, I will. Most of you have heard me talk about this bill before. This is the same bill that's been introduced the last three sessions. We have consistently reached out to the Press Association to work on this legislation. As at this point, there have been no meetings, no real negotiations on the bill. Let me illustrate one reason why we're concerned about it. This legislation makes all communication between public officials and public employees with constituents and members of the public, it makes that a public record. All communication, including emails. I think I'd ask you all to think about all of the issues that you deal with in a session and the flood of emails that you receive. All of that will become public record. And anyone with an email address can send an email and ask you for that, and you will have 14 days. You and every other public official and employee in the state. Think you understand how difficult that would be. Except that if you'll look on page 16, you'll see that the Alabama legislature is exempted in this bill from that requirement. The rest of public officials and public employees would have to follow that requirement. Certainly, I know that's one of the things that can be worked out. This bill, again, has been introduced for 3 sessions. We've consistently reached out to the Press Association to have meaningful negotiations. We're ready to do that whenever that occurs, Mr. Chairman.
Thank you very much, Mr. Braswell. Mr. Dennis Bailey.
Thank you, Mr. Chairman. Dennis Bailey, General Counsel, Alabama Press Association for 35 years. There are 4 reasons that this bill needs to be passed. It adds a response time that we don't have now. It specifies fees that people will have to pay in advance, so they'll know what they'll have to pay. It provides an administrative remedy, a very quick and inexpensive way to get a response from the public records counselor who will be created by this act. And it sets penalties for what is called withholding records without reasonable justification. Thank you.
Thank you very much, sir.
Mr. Chairman,
Yes,
one
Senator,
quick question.
Yes, sir.
Senator Smith.
You being general counsel is the reason I chose to ask you this, being a legal. The gentleman that just came up here before you, the statement he made about the emails, any communication whatsoever by those elected officials with anybody, is that an accurate statement that he made? That any communication by an elected person, you understand what I'm saying? Any, I ain't talking about if they dealing on this bill or anything, any communication with a constituent that you talking to, they email you about trash got to be picked up. And you say, okay, I'll get the trash. You sending me it back. That's got to be provided in this bill.
There are 18 exceptions to what is an open record in this bill. All of them memorialize the current state of the law. This bill does not change what is a public record and what is not a public record. It provides all the exemptions that you have. So there may be 2 or 3 exemptions to an email you get, let's say about buying property that you're thinking about buying. That would be excluded. If it falls within one of the exclusions, it would be excluded, and that's the current law. This law does not change what is excluded and what is not excluded from the definition of a public record by the court system. The courts have already established because the act is current act is so vague, the courts have already spoken about it. So this act does not change the law in the respect you're asking me.
One last question. Cannot what you want to get done, you mentioned 4 things right there, be done without whatever the excessive other things that are placed in this bill to be effective to do what you all are trying to do.
Can you give me an example?
Understand what I'm getting at? I know you got to comb this bill 10,000 times before it got here to us. So if you can understand what I'm saying, that you all may have had 4, you mentioned 4, it could be 5.
It's
4 things. Beyond them, those 4 things, there's a lot more in this bill. There's a lot more in here than just them 4 things. So beyond that, is all the rest of this stuff necessary that's being changed in here to effectuate what you just said to get those 4? Cannot you get those 4 based on what you just said and not whatever else is maybe an additional in here? And I say that because many times we have bills. We got this group over here, not y'all, but I mean, we got this group, well, let's get that in. You know what I'm saying? We got to be, let's do this. We want to do that. You understand what I'm getting at now? And all of a sudden, it takes a different life, even though it has the breathing that you all have, the 4 things that you talked about. So that's my question on this bill.
We think this is a good bill the way it's written,
Okay.
but we will listen to any reasonable attempts to amend it, and we have.
Okay.
Thank you very much.
Thank you very much.
Sir, would you, Senator Singleton's question?
Question that on the 14 days in terms of trying to get the expediency of these records, right? What if it becomes something that the agency has to redact information and documents that may be a voluminous kind of document that would take them beyond 14 days? Is there anything that will give them that kind of time to be able to get you the document based on redacting personal information or sensitive information in those documents?
Yes, sir. Go to the public records counselor, assert that it's a burdensome or a difficult request that they're dealing with, and they can get additional time from the counselor at a reasonable cost in a very quick time.
All right, thank you.
Thank you very much.
I mean, they don't pay anything.
Yes, ma'am. Thank you. Thank you, sir. I'm sorry, sir. Could you come back, Senator Coleman Madison?
Can you tell me if you know whether the League of Municipalities is supportive of this bill? There are a lot of small cities that this would impact. So have you all spoken with them about this? They represent all of the cities in the state of Alabama.
Well, I'm not personally involved in any of the lobbying, but I believe they have. They have talked to us, and we have talked to them many times in the past when we've had open records and open meetings issues.
Do you know what their position was?
On this bill, I do not.
I don't know if anybody's here from the league, sir.
Thank you very much, sir. Thank you, ma'am. And now the last one, Miss Jane Williamson, Alabama Association of School Boards.
Good morning. I had a lot of good stuff written here for you, but I've marked half of it out. So let me jump in here. Senator Smitherman, the answer to your question is yes. That email about the trash pickup would be a public record. And let me just say, a lot of what's in this bill, we're okay with. Mr. Bailey is correct that, the argument is not about what's a public record, I think, for most of us. It's about the how and the when. I'm going to give you one quick real-life example. In April 2020, while every public school in Alabama was closed due to the pandemic, dozens of superintendents received a public records request. It asked for an electronic copy of the following information. I can do it in 10 seconds. Employer name, employer zip code, first name, middle initial, last name, hire date, base salary, bonus amount, overtime amount, gross annual wages, and position title. That request came from an Alabama citizen who is representing a private company in Illinois that calls itself one of the largest private government records databases in the world. Of course, most school boards, most cities and towns don't have a system that'll spit out that information just that way. So it takes time and it takes work to get that things done. But we responded to that request because we had to. Our issue is the how and the when of how to do this. We are trying to do the right things, and we know we need a better law. We want a better law, and we've been at the table. Senator Coleman Madison, we have talked to the league, and they are not supportive of this bill. We are supportive of getting a better law, and we want to work. We want to work and get one because we need a better law. So we ask you to oppose it just in its current form.
Thank you very much, ma'am.
Thank you.
And we are now through with the public hearing. I'm going to ask a couple of questions here. Senator Chambliss, when's your next meeting? I'm sorry? 9:30. Representative Holmes? 9:30. And we have Senator Butler here at 9. Senator Orr, this is your bill. We finished with your public hearing. Would you mind if I jumped and got Senator Butler out of the way so he can go to his 9 o'clock meeting and come back to your bill?
If that's the chairman's prerogative,
I mean, if you wouldn't mind, I'd appreciate it. I think this might take a few minutes with your
All right.
some questions.
Thank
The clerk could call the roll, please.
Senator Albritton. No, roll. Senator Coleman Madison. Senator Figures.
We haven't called the roll yet.
Just call roll. Senator Figures. Here.
I am here.
Senator Gavan. Senator Marsh. Senator Orr. Senator Singleton. Senator Smitherman. Senator Stutz. Senator Barfoot. And Senator Wally.
Here.
We have a quorum.
Okay. Thank you, ma'am. If the clerk could call the bill by Senator Butler.
So Senate Bill 276 by Senator Butler.
Senator Butler, if you can do this quickly so we can get back to Senator Orr's bill.
I will do it quick as I can. Thank you. Senate Bill 276 comes from a issue that's in my district involving grandparents. I'll give you briefly. There's a lady in the district that went to prison for about 5 years. And during that time, the grandparents kept the child, a young girl, and 5 years later, or after the lady was released from prison, she no longer would let those parents. And they are very distraught. They're a well-respected family in the in the district, and everybody knows them. And this would allow that, if you would, the third paragraph on the synopsis gives it pretty good, but it allows what's in the best interest of the child for those grandparents to be able to visit with a child. And most of you are attorneys or not, you can go through the bill and do whatever you need to do legally with it. But from the heart, this is doing something that's in the best interest of the child.
Thank you, Senator. I think Senator Smitherman has a question.
No, I just want to tell you, I appreciate you doing this. If you look back in time, and I don't know before I got here, I didn't go back that deep, but I think I'm the person that filed probably the first grandparents' bill back about 20 years ago. And for the same kind of reasons, except this case, one of the parents died. The one that wasn't together. Mom stayed with the grandparent, died. Other guy, same kind of thing that you're saying right there. So I know you're right about that. There's a few things we may have to ultimately tweak to fall into the legal aspect, not your intent. But I'm with you 10,000% on this bill right here.
Thank you, Senator.
10,000. Thank you.
Senator Gillian.
Thank you, Mr. Chairman. So, Senator Butler, of course, these things can always cut both ways. I mean, there's situations of abuses on both sides. I actually have a situation in my district that is probably abuse on the flip side of this, and I would like to work with you about adding some language about how out-of-state orders are affected and that they should comply with Alabama law, that should be our public policy of what we do here. In other words, not have a grandparent come in from another state and say, well, our laws are different than Alabama's, we're going to ignore the best interest of the child. So I just would like to work with you on that.
Well, I appreciate that. Actually, I know 2 cases in my district where these are separate and different kind of things. No abuse in there except that the parents won't let the grandchildren have any contact. They will send them a Christmas gift. They'll send it back. They'll send them a birthday gift. They'll send it back. So do whatever you need to do with the bill, but fix it so that the child is the one that is taken care of in this situation.
Thank you, Senator Butler. And Senator Van brings up some good points I think have been echoed by members of the committee. But I know Senator Smitherman has a question.
No, I want to move
Senator Smitherman's favorite report. Second by Senator Coleman Madison and Senator Albritton. The clerk will call the roll.
Okay. Senator Albritton. Senator Coleman Madison. Senator Figures. Senator Gavan. Senator Marsh. Senator Orr.
Aye.
Senator Singleton. Senator Smitherman.
Aye.
Senator Stutz. Sorry. Senator Barfoot.
Aye.
Senator Watley.
Aye.
Favorable 10-0.
Bill to the federal report 10-0. Thank you, Senator
Thank you,
Butler.
Mr.
Appreciate you.
So
The
sorry.
clerk will call back to Senate
Okay.
the first bill on the agenda.
Senate Bill 165 by Senator Orr.
Senate Bill 165 by Senator Orr. We've had the public hearing on this bill. Senator Orr, would you like to present the bill?
I have an amendment, Mr. Chairman, from some of the groups that have expressed some concern, and there are others that we are still talking to. I think there's a meeting with the County Commission Association. He's nodding his head, I see out of the corner of my eye, next week to start hammering out a lot of those concerns from the locals. I'll leave it to the pleasure of the committee. I'd like to move adoption of the amendment if that's acceptable, Mr. Chairman.
Senator Orr has offered the amendment.
This comes from the probate judges, the Office of Information Technology, and Electric Cities, is my understanding, are the 3 that are included in this amendment. And then there are others that, like the Department of Archives and some others that we're working with. And then, as you heard, working with the County Commission Association and others to make additional changes. So I'd like to move adoption of the amendment, Mr. Chairman, now, and then kind of talk about where we go from here.
Okay, we have an offer amendment by Senator Orr. I'll second the amendment. We have a question by Senator Smitherman.
Yeah, thank you. I have more of a comment. Senator, I would hope that just like these people who are in this amendment who have addressed whatever those unique concerns, I would hope before this bill hit the floor or the special order calendar, that all these people are talked to. Municipalities, school boards, everybody. I want them to be talked to work out those unique things. You all heard me say this, and you're gonna hear me say it more and more. So many times these bills have consequential effect on people that we don't take into account because we don't bring them to the table to expose and address those and put those out there on the table to see how we can do that. I said this again when I heard the comment about the fact that people have not talked to people in this. I think that it would be an injustice to those people to not be able to come to the table, and so they bring those unique concerns. So I wanted to say that before we move forward with this bill, that I would greatly hope that every person that got a concern, municipalities, school boards, everybody who would have to provide information would bring their unique concerns. Because as a young lady who just sat down and so eloquently said that everybody ain't set up the same way. Everybody's financial, everybody's procedures and whatnot. So one size don't fit all to provide for this. The last thing I'm gonna say is that if we don't do that, in my opinion, what we are really doing in those towns, for instance, like she said about with the school closing and the superintendents and those counties and things, what we're just doing is setting these people up to fail. We setting these people up to be guilty of whatever it is in here when they can't implement and do what we tell them. That's idealistic, all this what we talk about, but realistic, I deal with reality. And the realism is that we setting up some of these people who can't, don't have staff, don't have funds, don't have the technology, don't have whatever it is to do what they need to do. We're setting them up to fail. So we got to sit down and talk to them to see what it is, that what framework, even if we decide they got to provide, that they have to provide it versus somebody who can go and push a button,
Thank you.
print it out, and send it to these people.
Thank you, Senator Smith. You make some good points. We have a first and a second on the amendment. Wait, comment on the amendment? On the amendment, or you want to?
I just want to make a comment
Yes,
on
ma'am.
the
Go
bill. I totally agree with Senator Smitherman, and I will vote to get the bill out, but I would like to have Senator Orr's commitment that he will do those things that Senator Smitherman said without me repeating
already
all
there.
of that.
Already
Thank
there.
you. Thank you.
Thank you, Senator Figures. Thank you, Senator Orr. We have a first and second on the amendment. Will the clerk call the roll of the amendment, please?
Senator Albritton? Aye. Senator Coleman Madison? Aye. Senator Figures? Aye. Senator Gavan? Aye. Senator Orr?
Aye.
Senator Singleton? Aye. Senator Smitherman?
Aye.
Senator Stutz? Aye. Senator Barfoot? Aye. Senator Watley?
Aye.
10-0 amendment.
Amendment is
passes.
adopted. Is there any discussion further on the bill? Senator Gavan.
Thank you, Mr. Chairman. First of all, I do think this actually is an improvement over what the previous bill that was submitted in the prior sessions. And I understand that there's a balance, and unfortunately, I wish and it's not necessarily their fault, it's just market forces. We don't have the press that we used to have when I was started following things in junior high school and going forward. We're in a different world, and we actually need the press at more public meetings than they are right now to be able to be a watchdog. But I've got a number of problems with this, and I'm not going to be able to go over them all today. Not all cities and counties are created equal. Macon County does not have the resources Jefferson County has. Town of Gurley doesn't have the access to resources that the city of Huntsville has. Some of these people, as far as some of these entities, as far as public employees, maybe they've only got Sheriff Taylor and Barney Fife there to take care of things, and how are they going to be able to address this when they need to be on the street patrolling, doing law enforcement? So I think we've got to look at what type of groups we're talking about. Even government agencies aren't. I think we need to specify that we talk about current law-making exemptions. I think we need to specify certain things, legal work, confidentiality, and things like that, because trust me, if it's not written in this statute, somebody's going to try to get something, and somebody's going to be confused about it. One specific example is existing law provides that appraisals are supposed to be produced in a redacted form in a certain amount of time after the project is over. This says appraisals are responsible. First of all, we don't disclose appraisals in the state of Alabama. In the current law provides for a redacted form of that. And also it provides that we don't do it until the end of a project, because we start these road projects and they may go on for years. And what happens is, the lawyer for owner A goes and gets the appraisal, and he's going to tear it up for owner B. On owner B's property, and it's just problematic, and we've just got to be consistent in our law there. We've got issues on page 10 talking about private individuals. The intent should be towards a custodian. I think that language is a problem there. One of the biggest problems I've got with this is that a person can be anybody, I guess, in the world, and we need to limit this to Alabama individuals, Alabama corporations, people that are qualified to do business here, have a physical presence here, not just, I'm operating some research firm in Colorado and I want to make the city of Huntsville or city of Birmingham and whatnot jump through hoops so I can have marketing information to sell for a profit. I think that's just out of bounds. I mean, our job should be to let the Alabama press have access to this, and to have Alabama citizens have access to their government, and not do the work for private companies out there.
I think you made.
Oh, I've got
point,
pages left.
Do you want to keep going, or you want to?
Well,
we got some other guys that want to.
I'm just saying that this is. There are so many things in here that that the statement is this is supposed to be help give clarity. There's so many things in here that beauty's in the eye of the beholder. We're going to litigate what these terms mean in here as well. So there are just a lot of issues in here that we've got to take the time. I mean, in redaction, people act like, they're just going to redact it. That takes time to redact a document. And then there's just situations of abusive situations out here that we've got to be able to deal with. So anyway, obviously, I've got a lot of problems. Both Senator Orr and I have another committee meeting we've got to be at before I could get through my list of problems.
I appreciate your comments there, Senator Gavan. I know we have Senator Coleman Madison will say something, and then we have Senator Barfoot. So, Coleman Madison.
Thank you, Mr. Chairman. I will be brief. Senator Orr, first of all, I want to thank you for bringing the bill. I think I understand your intent. And I do support the media, because I understand right now, were it not for the media, a lot of things would not have been exposed. But there has got to be a balance. We represent cities, towns, people, and individuals, and we talked about all these entities that we didn't even think about. We didn't understand how it would impact the boards of education and a lot of things, anything that is public. And so I just want us to try to strike a balance here with this, that we don't have something in this that could be abused and misused by the public, and at the same time create a fairness to those public entities that are really trying and struggling, especially during times like this.
Thank you.
Until we get there, Senator Orr, I can't support it in this form.
Thank you, Senator. Senator Barefoot.
All right. First of all, with the risk of beating a dead horse, I echo the same comments that my colleagues have mentioned here. Real life experience on a board where there was litigation that was anticipated litigation, and one of the grieved parties used an assistant, the only person that cut payroll and washed tables and cleaned up. I mean, did everything. Occupied about half of her time. I am agreeable with the concept and the intent. I think is good. I think we should have open records. If it's up for a vote today, I will vote to get it out of committee. But I would urge you to, as other members have said, to sit down and try to work out the details.
Thank you, Senator. Senator Albritton.
I'm prepared, if it's appropriate, to move a favorable report on
Move favorable report, Senator Albritton, second by Senator Orr. Are any other questions on the bill?
The thing I would like to add is I agree with Senator Gavan, Senator Figures, Senator Barfoot, Senator Smitherman, Senator Coleman.
What about me?
You didn't say much about the, and of course, Senator Stutz. I'll agree with you too, whatever you're thinking over there. This is a work in progress. I appreciate the confidence of certain senators to move it out of committee. You know, the bill's been filed twice already this quadrennium. Didn't even get a committee hearing thanks to the indulgence of the chairman. We've had it, and you've heard me the first time it came up. Come one, come all. Please come forward with your amendments. There are a couple other groups that have come forward. And as you heard getting with the point you make about Macon County and Gurley and resources. Mr. Brassfield will be bringing all those points to bear about the capabilities of particular poorer counties to do what the bill calls for. And as long as we're making progress, you'll never, and we still have some distance to go. It's not my intent to force things on the floor, but to keep